Good Monday evening and welcome on in for another episode of From Day One. We've got our auditor subsets and combination of the two tonight, as we have Father Skeptic and Law Talk with Mike together, as we have to handle some chili con carne. As much as I hate the guy, sometimes we have to fucking deal with him. So it seems Chili went ahead and filed a lawsuit, of all things. So, we have here is Chili's stupid lawsuit. So, with that being said, let's hear what's going on with somebody who's trying to get out of that case.
Can read along.
Oh boy.
It's off of Pacer. Do you have a Pacer account, Mike?
I sure do.
Okay. Do you need any of the relevant things? Because I want to see if there's been any update to this case. So maybe you can look this up while I'm reading this.
No. I can't do that midstream. No way.
Okay. No mystery. No.
I have my assistant Yesenia look stuff up on Pacer because I hate it so much.
Okay. So
it's workable, but it's just a poorly written program. So you gotta fuss with it. That's all.
All right. So Mike, you stop me when need stopped. Okay. I will read. You or Bacon, Mr. Piglet, stop me if I need to be stopped at any point in time. You too, Mike. Okay. All right, because I'm just reading until I feel I need to stop, or you tell me. All right. So this was filed, United States District Court, Southern District of Ohio, Western Division, whatever the case may be. Jose Maria de Castro, the plaintiff, versus Pam Wagner, who is, I believe, the chief of police there. And it also includes some defendants. All right. Let's see. It's a Lawrence County defendant's motion to dismiss. So this is, in the process, they...
Wait, where's Lawrence County?
I believe that's Ohio, is that not?
Yeah, I think it's Southern Ohio. Ironton, that's what I'm asking. This is the Ironton crap?
Yes, this is all the Ironton stuff. Okay. So, originally, Chili de Castro filed a federal lawsuit of deprivation of rights, I believe. Is that correct, Blue Bacon? Was that the original lawsuit that he filed?
He said that he was unlawfully arrested, despite the fact that he intended to get arrested. He knew what he was doing was wrong. He said that his phone had been unlawfully seized. There are a few lawsuits. I think that's for this one. There were some other ones about the news stations, and I'm mad at them, but I don't think there's anything. Well, actual ground.
This one,
they're going to try. They'll lay out the claims, and this is a motion to dismiss. They'll lay out what the underlying lawsuit is. That will be one of the first things you'll see.
Okay, so I'll just start reading until Mike tells me and Bacon to shut up. Now comes the Lawrence County defendants, Major Chapman, Jane Doe, and Lawrence County by counsel, respectfully requesting this court dismiss plaintiffs' claims against the aforesaid defendants pursuant to. A memorandum in support is attached hereto and incorporated by reference. And we're going to get to the memorandum right now. All right, memorandum in support. Now, this is a memorandum in support of the dismissal. So these will be saying why this should be dismissed. Number one, statement of the case. We're just going to call him Chili. Proceeding pro se. So good on Mike for pro se court fails. Coming in real quick. Is a known journalist, vlogger, and reporter on YouTube and other media outlets. Citation fucking needed. They did provide it. We will see what it is that makes him classified as a journalist. Plaintiff is a self-proclaimed civil rights activist who publishes video recordings on media forums such as YouTube, Facebook, Instagram, and the like since approximately 2020. According to the plaintiff, the financial benefits of his postings have been an essential economic support for him since this time. I do want to stop it here because he has said multiple times in his videos that he does not do this for money. So this would have to be a refutation of what he has made claims of it being an essential economic support for him. So again, there is a citation for that. So we can go check that citation out when it's all done. But it's a contradiction that he often makes. I just wanted to point that out. It's not really relevant to the dismissal, but it is relevant to us that are watching him. On March 29, 2022, plaintiff, who is not a resident of Ironton, Ohio, was involved in a protest that occurred at Ironton City Hall. Plaintiff claims that at approximately 4 p.m. on the aforesaid date, he was at Ironton City Hall peacefully protesting. The complaint sets forth at approximately 5 p.m., a City of Ironton employee announced that the City Hall building was closing and going to be locked. After City Hall...
I believe in part of his complaint, unless it didn't make the final draft, he said that he received 0 warnings for it.
I'm not 100% sure on, but but we've all seen that video. He was clearly told to get out. He was clearly warned. They were polite. It wasn't until he refused and said, "I'm here protesting," that they got the police, which was the right move for them to do. They can't just physically throw him out. That's the police's job. Call the police, let them deal with it. That's what they did. All right. Let's see. After City Hall closed and the plaintiff did not exit the building, he was seized and handcuffed and placed under arrest by defendants Spoljaric, Blankenship, McKnight, and Fouch. The aforesaid defendants are police officers with the Ironton Police Department. Then, according to plaintiff, he was taken to the booking area where several criminal charges were brought against him, and he was patted down, his person searched, and personal property, including his wallet, car key, and other items, including his iPhone 12 Max Pro, were taken. During the booking process, the complaint claims that Major Chapman with the Lawrence County Sheriff's Department told plaintiff that he had to get his social security number. Plaintiff objected, and according to the complaint, Chapman told him that he would be listed as a John Doe and incarcerated for up to 3 months until the FBI confirmed his identity. Yeah, that's something that, I want to point this out. A lot of First Amendment auditors say, that they refuse to give ID. And in certain states, you do have that right in certain states. Like in the state I live in Texas, they don't have the right to just stop you and ask you for your ID. But in other states, they do. And in fact, in some states, even where they don't have the right to stop and ask you for your ID, they do have the right to ask you for your ID when you're part of an investigation. Now, you have the right to refuse that ID, but here's what comes with that right to refuse to identify yourself. They still have to identify you. So they're going to do it one of 2 ways. They're going to take you in, and they're going to run a thumbprint scanner over it, and you're going to sit in jail until they get a valid confirmation of your identification. And if you don't have any warrants, they're going to release you, and all of that will be for nothing. Or the second option is you're just going to give in and give up your ID, because that's what everybody does. When it comes down to I'm not in trouble, I've done nothing wrong, I am a part of an investigation, I do have to give my ID up, the cop will explain that and say, here's your other alternative. You can go to jail, and we can keep you there until we have you identified. And they usually give it up then. Now, in this situation, go ahead.
For Texas, if you're arrested, you do have to actually identify.
Yes.
Arrested, yes. Detained varies from state to state, sometimes county to county. Absolutely correct. I can tell you from how we did it, if you didn't identify, where are we going to send your stuff? Where are we going to send the citation? So, yeah, you are held. And 3 months is a long time. I think
that'd be a long time. Yeah, that'd be a really long time.
It would probably be a few days.
Yeah.
But he would be in some sort of holding cell or facility until they could ascertain his exact identity. So, as far as social security number goes, that is probably the best thing to ask him for. He doesn't have a history of using fake IDs.
Yeah. All right. So I just wanted to let everybody know. That's what they're telling him they'll do. That he's going to have to sit in jail until they actually ID him through some other sort of system. If he doesn't want to just give up his state provided ID. All right, so here we go. The complaint claims that Chapman then demanded plaintiff's social security number and threatened him with a felony charge of obstruction of justice if plaintiff did not give him his social security number. Plaintiff claims that if he provided his social security number to Chapman under his threat, I'm sorry, I read that wrong. Plaintiff claims that he provided his social security number to Chapman under his threat. According to the complainant, after approximately 2 hours, Chilli was required to post bond for alleged criminal violations, was released, and his property returned to him, all but his cell phone recording device, which he uses for his occupation and personal record, which I believe they can keep as evidence if you use it to record yourself committing a crime. So, not sure he's going to have a case there to really fight against.
Some questions arise whether or not it would matter if it was a live stream, because if it's live streamed, do you really need a phone? The argument can be made, well, he can delete the live stream from his phone, and therefore you were going to hold a counter argument, he can delete it from any computer. So if he really wanted to make a fuss about it, I think there's enough to make a fuss. Would he win? I don't know, but there's certainly a conversation that could be had at the very least.
All right, let's see. There was something shared with me on Discord that the person that sent that to me, be a little bit more specific. I'm in the middle of a live stream, so I can't really. It's relevant to what's going on right now, so I'd like to get more clarification from it because we might need to address it. But if she will, if whoever sent it to me will just go ahead and clarify a little bit more in the Discord, thank you. All right, so several days later, on April 5th, 2022, plaintiff was contacted by Darren Habercorn, a person unknown to the plaintiff, who allegedly received a telephone call from an individual working for the Lawrence County Clerk of Court's office regarding chili. The complainant claims that Jane Doe, her first name possibly Samantha, called and reported to him that Chili had stolen his telephone number and had used it to call her office and made harassing and obscene phone calls. Jane Doe further stated the plaintiff was crazy and that he had stolen other people's phone numbers and done likewise. Have you heard anything about that, Blue Bacon?
I've heard some stuff.
Hijacking or probably spoofing, right? Just spoofing numbers as it's calling people.
So before Chili was trying to get my number, I had heard rumors, probably from something having to do with this particular case. However, once it became clear Chili was trying to get my number, I got contacted by a lot of people saying, do not give him anything because he's doing this with other people. Do I have evidence to support that? No. But are there a lot of people that are very concerned about it? Yes. Unfortunately, I can't confirm anything either way.
All right. Well, I just wanted to make sure.
I got the same sort of warnings about him.
He doesn't have my number. I'm not about to give it to him. Based upon the aforesaid allegations, plaintiff filed a complaint in the United States District Court, Southern District of Ohio, Western District, on April 13th, 2022. The complaint names the following defendants. Pam Wagner, Brad Spoljaric, Chance Blankenship, Evan McKnight, Officer Fouch, Major Chapman, Jane Doe, City of Ironton, and Lawrence County, Ohio. The complaint sets forth the following causes of action. Cause 1, 42 U.S.C. 1983, violation of the Fourth Amendment against Wagner, Spoljaric, Blankenship, McKnight, and Fouch. So that's the first cause they're going to have ask for dismissal on, a violation of Fourth Amendment rights, or based on violation of Fourth Amendment rights. There are 42 U.S.C. 1983, again a violation of Fourth Amendment rights against Chapman. Cause 3, 14th Amendment violation, that's due process of law against the defendant. Cause 4, for 42 U.S.C. 1983, another violation of First Amendment rights against the defendants. Cause 5 would be a violation of the Fourth Amendment rights against Chapman. Cause 6 is a violation of the 14th Amendment against Jane Doe, which I think that's the lady. Isn't Jane Doe? Sorry for stopping, guys, but Blue Bacon, isn't Jane Doe the lady that I covered? The one that was like, "You're the creator of chaos." Isn't that the one that?
God, I hope so. I hope so.
And she's not a government
employee.
employee.
Her name is Crispy.
Her name is what?
Well, it's not her official name, but they call her Crispy because she likes Krispy Kremes, or so I'm told.
Oh.
So doesn't.
Yeah. So okay.
And she's cool as hell.
So apparently, from what I have known, from what I've heard, from Blue Bacon's source, is that she doesn't even work for the government. So to file a cause against her for a violation of 14th Amendment rights would be pretty hard if she's just a normal citizen. Because
it's downright wacky.
Yeah, it's wacky. It's trying to. She didn't citizens arrest him in that video, as far as I know. And cause number 7 is Monell claim a mono. What's a mono claim?
That's for his phone, I believe.
Okay, a claim against Ironton and Lawrence County for failure to properly train and supervise. Okay, so I guess he's saying that they're Their bad
They've
training.
seen illegally. I think that's what his argument was for that.
Yeah. Okay. For the reasons set forth below, the Lawrence County defendants maintain that the claims set forth in the complaint fail to state a claim upon which relief can be granted pursuant to Federal R.Civ. P. 12b-6. What does that mean, Mike? It's the last sentence. For the reasons set forth below, the Lawrence County defendants maintain that the claims set forth in the complaint fail to state a claim upon which relief can be granted pursuant to that.
I mean, this just that he failed to state a claim, which he has. I can't remember Monell claim. Oh my God, I filed a 1983 claim, but it's been a few years. I can't remember. But he has failed to state a claim here. Why? Let's start with the defendant who's not a government employee. That's just gone. It just doesn't fit within the statute. The other violations, he's just not going to be able to prove it. He got arrested, and then the usual things happen as a result of that arrest. It's just not going to fly.
Yeah, he doesn't say anything out of the ordinary for arrest procedures, and he wasn't committing a crime.
Well, let's start with this. Let's start with this. This thing is absolutely dead on arrival if he gets convicted of anything.
What do you mean? Like if he gets convicted of the criminal trespass?
Whatever. What was it? Disorderly conduct?
Disorderly conduct, I actually believe it is what they charged him with.
Disorderly trespass and obstruction, I believe.
I'm oversimplifying it to make it palatable for people, but if he gets convicted of disorderly conduct, then all of this is sort of justified immediately. If he doesn't, or they pitch it, or he even beats it, that doesn't mean he wins. But you are nowhere if you get convicted on the underlying charge.
Yeah.
Nowhere. Because you're effectively saying it's some sort of malicious prosecution, and if you get convicted on it, well, that takes that off the table.
Okay. All right, so I'll continue to read. All right, motion to dismiss standard. Rule 12b-6 permits dismissal of a complaint for failure to state a claim upon which relief can be granted, which is exactly what Mike was just explaining. The complaint must contain a short and plain statement of the claim showing the pleader is entitled to relief. This goes with every case, by the way, guys. When you file this, you have to have these. This is part of what makes your case even viable is the short and plain statement saying exactly why you deserve relief and then you go into your evidence and your explanation, your more in-depth detail. But anyway, okay. The plaintiff's ground for relief must entail more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. Bell Atlantic Corp. v. Twombly, 550 U.S. 2007. All right.
Which is exactly what this is.
Yes. Although a plaintiff...
You violated the Fourth Amendment because I alleged you violated the Fourth Amendment.
Exactly. You're a tyrant because I say you're a tyrant.
Yeah, you violated the Fourth Amendment because you broke into my house at 4 o'clock in the morning and took my stuff with no warrant. Boom. Now you violated the Fourth Amendment. You just circular logic. You violated it because I said so. Does not fly. This case is always cited in these motions to dismiss.
Yeah. Although a plaintiff need not plead specific facts, the complaint must give the defendant fair notice of what the claim is and the grounds upon which it rests. Nader v. Blackwell, 2008. Quoting Erickson v. Pardis, 2007, a naked assertion gets the complaint close to stating a claim, but without some further factual enhancement, it stops short of the line between possibility and plausibility. Twombly.
Yep.
To survive a motion to dismiss under Federal Reserve, I don't know how to. I think it's a civil rule 12b-6. A complaint
Civil Procedure 12b-6.
Okay, yeah, Federal Rule Civil Procedure 12b-6. We'll just shorten it to 12b6, a complaint must contain either direct or inferential allegations respecting all the material elements to sustain a recovery under some viable legal theory. Clusty versus Taco Bell. Yo quiero Taco Bell. 1995. Alright. Law and argument. This is where we're going to get into the nastiness. A plaintiff's second and fifth cause of action fail to state a claim upon which relief can be granted. The Fourth Amendment protects the right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Davenpeck v. Alford. Accordingly, the Fourth Amendment protects two types of expectations, one involving searches, the other seizures. United States v. Lewis. Let's see. Quoting United States v. Jacobs. Oh, well, I guess that was part of that. All right. The right to informational privacy arises from the 14th Amendment. Johnson v. Rita. See also Doe v. Delhi. The right to non-disclosure of one's medical information emanates from a different source and protects different interests than the right to be free from unreasonable searches and seizures. The Sixth Circuit narrowly applies the right to informational privacy only to interests that implicate a fundamental liberty interest, and that would be the Sixth Circuit has limited such a violation to only two instances. One, where the release of personal information could lead to bodily harm, as in Kallstrom v. City of Columbus. Now, I already knew this one. This is going to be your undercover cop, okay? Can't release the identity of an undercover cop that infiltrated a mafia, den and brought them down from the inside. If releasing his identity will hurt him or his family, they're not going to release the identity. Two, where the information released was of a sexual, personal, and humiliating nature, as in Block. Okay? So those are the two situations. Now, we can go ahead and say that Chili's event is definitely humiliating, but nobody wants to have sex with that guy, so we're gonna avoid the sexual and personal nature of that. Just the humiliating part. And no, neither one of those apply to Chili's situation. Case law clearly establishes that the Constitution does not provide a right to privacy in one's social security number. Pay attention, Chili. Pay attention. Irvin versus S. Cent, Kentucky. All right. Civil action number 113 CVP 104 if you're listening. -M. All right. We also agree that the Constitution does not provide a right to privacy in one's social security number. Like the Seventh Circuit and other federal courts to address this question, we decline to expand the constitutional right to privacy to cover the collections of social security numbers. All right, Mike, would you care to chime in at this point? Well, Mike appears to have gone blank.
It's good so far. This is a motion to dismiss, and it's a high standard to get it dismissed. I suspect that this will be granted, but bear in mind it's very difficult. You're assuming facts most favorable to Chile here. So they're just saying, can you even plausibly, if we look at it, and can we even imagine a scenario where you win? It's very easy to overcome if you have some facts. He does allege some stuff. I don't think it's sufficient. I think this motion probably gets granted.
This one probably gets granted.
But even if this motion gets denied, it doesn't mean that Chile wins. It just means that, we didn't blow you out just on the face of the complaint.
Right. He still has to win it in court. This is just a
it'd be easier to win as a motion for summary judgment and just say, all right, well, let's look at some of the actual facts. All right, they don't rise to the level of, I'm making a finding, you lose. That's easier, but you start with a motion to dismiss. That's the first thing you do.
Okay.
If you're defending this.
All right. In the case before this court, the complaint alleges that Chapman knew or should have known that a person refusing to provide a Social Security number in order to complete the processing of an arrest is not a violation of any law. Plaintiff further claims that it is a Fourth Amendment violation when compelling someone to do so under threat of punishment, which I believe this document already cited. The two cases already that this document has cited that show that that's not the case, that the law of the land does not see it the same way that Chile sees it. It's not a violation of your Fourth Amendment rights to have to disclose that.
No, but there might be other cases out there that would be more favorable. I don't suspect chili. I don't know if they are because I don't do this all day. But you might be able to respond to that. There may be other cases, but I highly doubt that he's going to figure it out, even if they exist.
Yeah, I'm thinking more. This is more along the lines of one of those. Look, you can give us your Social Security and make life easy on you, or don't and make it hard on you. And he was like, okay, fine, it's a violation of my rights, but here you go. And that's not a violation of your rights when it goes down like that,
Right.
All right, so the complaint fails to address how plaintiff's Fourth Amendment rights were allegedly violated by Chapman, which he doesn't. He doesn't explain, he just says it. The complaint never alleges Chapman unlawfully seized or searched plaintiff or his property. Moreover, even if plaintiff is claiming a constitutional violation of his right to privacy, his claim still fails. As the case law set forth above provides, plaintiff's constitutional rights were not violated because he was required to provide a Social Security number. Plaintiff's complaint provides nothing more than hollow and conclusory allegations, which fail to overcome a motion to dismiss pursuant to Civil Procedure 12b-6. Therefore, plaintiff's second and fifth causes of action fail to state a claim upon which relief can be granted and should be dismissed. Captain Mike, do you agree?
I do.
All right, 1 for 1.
I do, but now this does get into the judge's discretion. Their complaint is incredibly thin, but he does state something specific. Hey, my property was taken as a result of this arrest. So the judge is sitting there going, is there any way I can construe that as a violation, even though I don't honestly think it is, but is there any way, under any circumstance, could he prove that? And that's where it's difficult. At the motion to dismiss stage.
Right.
My hunch is that the judge grants this motion to dismiss because it's good, but I'm just saying it's a hell of a burden to overcome.
Okay, just so you know, every time you defend chili, you lose subscribers. Okay. Well, unsubscribe.
Well, I'm not defending him. I'm just saying what's set up in the federal court.
Chili called me on said on his video that me and him were best buds, and I lost about 2,500 subs that day. I was like, wait, what? I didn't say he was my friend. He said I was his friend. Why do I lose subs?
I've got everybody. I talked to you about this, Skeptic. I got a bunch of people saying that he's talking trash about me, and I'm like, I don't care. I've been so busy with the death trial and so many other things, I haven't even looked it up. I'm like, I'm sure. Yeah. I made a bunch of videos laughing at him because he's hilarious. I'm sure he doesn't like me. I'm sure he says bad things about me. I just don't care.
Hey, if you're losing 2,500 subs because of chili, can I have them? Just kidding. Just kidding, guys.
My favorite part of that was he's like, oh yeah, he's on our side, and then it was 10 seconds later, and he's like, wait, y'all are saying that Team Skeptic's over there talking shit about me? And I was like,
I was live streaming that when it happened. Yes. It's on my channel. I was live streaming it, and I'm like, I know Team Skeptic, and I'm, I'm not. I don't think this is right, but okay.
Okay. It wouldn't be the first time you've been delusional, but all right. Okay, so on to number B. Plaintiff's sixth cause of action fails to state a claim upon which relief can be granted. The 14th Amendment prohibits any state from depriving any person of life, liberty, or property without due process of law. Carluck versus Osborne. Let's see. The point is straightforward. The Due Process Clause provides that certain substantive rights, life, liberty, and property, cannot be deprived except pursuant to constitutionally adequate procedures. In other words, you can't be held against your will unless you've broken the law. They can't. It would be a violation of your constitutional rights for them to just jail you without you ever having broken the law, without you having gone through due process to prove your innocence, or for them to prove that you were guilty, because you ain't got to prove your innocence. They got to prove you're guilty. Historically, this guarantee of due process has been applied to deliberate decisions of governmental officials to deprive a person of life, liberty, or property. Daniels versus Williams, 474. Thus, merge negligence and is insufficient to trigger constitutional liability under the 14th Amendment's Due Process Clause. L.S. versus Mount Olive. See also Franklin versus Aycock. All right, the court concluded that negligent conduct which causes injury to be causes injury to a protected interest could not be considered a deprivation within the meaning of the 14th Amendment, stating that a contrary holding would trivialize the centuries-old process or principles of due process of law. The first inquiry in a 14th Amendment due process claim is whether the interest in stake is within the 14th Amendment's protection. Carlock said, that's citing Carlock, I'm sorry. The 14th Amendment's due process clause protects persons against deprivations of life, liberty, or property, and those who seek to invoke its procedural protection must establish that one of those interests is at stake. Again, you can't just make the claim. You have to show. You can't say, I was deprived for a USC 1832, or whatever the sovereign citizens like to say. Deprivation of, I'm going to get you for, conspiracy of deprivation of rights is one, and the other one is deprivation of rights. I believe it's USC 28 and 29, I think 38 or 39 maybe. But you can't just say that. You have to prove it. Only after reaching a conclusion that the interest claimed is within that protection does this court consider the form and nature of the process that is due. The complaint alleges that defendant Jane Doe, possibly Samantha, knew or should have known, Crispy, that any person willfully making a false complaint against another person is a crime. However, defamatory statements alone do not constitute a deprivation of liberty guaranteed by the 14th Amendment. I believe she called him the creator of chaos. And maybe he's looking at that as some kind of violation of due process of law.
She literally thought I created chaos. I don't know what to do.
Yeah. How am I ever going to live that one down, guys? Every time I go to get a new job, they search my name and it comes up creator of chaos by some crispy lady.
I know what a nickname is. I use a nickname in my daily life, but this one doesn't fly.
Jane Doe just tried to give me some bad stuff, and it's not even true. I've got videos. Go watch my channel, Delete Laws.
I don't create anything. You know that it's her?
Can we just delete him?
But I'm assuming.
I don't care. I don't care. I'm having fun with it, but I don't even know that they're referring to her.
I'm pretty sure it is. But I'm not 100%. I don't want to say that I'm 100% sure.
I mean, the only reason I say that is that was like, I think a few days later or something. He goes and gets arrested, and then a few days later, he's talking about how corrupt Ironton is and walking around and trying to feed people stories. And she comes by and tells him, he's a
load of crap,
and goes about her day. That's what happened. So it wasn't the date of the arrest.
This wouldn't have been the clerk that was saying that her number had been given away, right? Because then it would be someone he talked to while trying to make the protest happen.
I don't know.
I think this was the girl who was supposedly
because if you're doing a motion to dismiss, I think it's probably some person where he was in some municipal building or something. I do think it's probably a government worker, because if not, and I'm defending this. My first thing is that he's making a claim against somebody who has no association with the government.
So the way I was explained was that he believed her to be a prosecutor there, when actually she has an office inside of that building. So she has like her own business that's an office inside of that building. So that's why.
Like rents space or something. Okay.
So he had said that, or what was told to me was said that he had added somebody that was a non-government official to a government or to a federal lawsuit. So I'm assuming it was her, because of all the interactions I've seen, she was the only exclusively non-governmental employee, even including the janitor. I'm considering him a governmental employee by this standard.
Oh yeah, the one that he had plugged.
Non-governmental employee that was in the mix, and it references a non-governmental employee. That's the only reason I'm putting those assumptions together. I could be wrong. She's still crispy and he's still chilly, so. All right. So
we can't make.
Go ahead and continue, Skeptic.
It is, yeah. All right, let's see.
According to raise a toast to Chili for creating this chaos and giving me something to chuckle at.
Chili,
giving all of us something to chuckle at.
Being a jackass.
Really, I mean, it's good.
We wouldn't be able to do this without you, sir. All right, here we go. Back to the complaint. According to plaintiff, if that person is in their official capacity, such as Jane Doe, doing so to subject Castro to being falsely arrested is a violation of his 14th Amendment rights due to due process of law. So I don't know. Maybe I did get that one wrong because now it's saying it led to his arrest, and I think those two happened on separate days.
Yep.
I believe you're right on that they were separate days.
I think a government employee at this municipal center said, hey, this guy is being annoying, and alerted the cops, and now he's adding them. And then that would make sense, at least to the extent that it's under 1983.
Yeah. All right, let's see. Plaintiff was arrested on March
30th. You know.
Okay, go ahead and continue.
Wait, oh my God! No, wait, hold on. Look at the next line, though, Mike. Look at the next line. Plaintiff was arrested on March 31st, 2022. However, according to Exhibit 4 attached to the complaint, Jane Doe's statements regarding plaintiff did not occur until April 1st, 2022.
So it is the girl.
After plaintiff was arrested.
It is her.
Maybe it is her.
Yep. So it is
Crispy.
I was leaning for, but no, he is that stupid.
He is that dumb.
He is that stupid.
You're right, Mike. He is that stupid.
The allegation.
God damn.
Man, but bye-bye subscribers for Law Talk with Mike. You know?
Come on over to GC Hero Wars, guys.
The allegations set forth in the complaint and exhibits attached thereto establish that plaintiff was never arrested as a result of Jane Doe's statements. An allegation regarding plaintiff being falsely arrested is merely based on a hypothetical situation, see Moss v. United States, noting that if the conflict is as to a matter that is irrelevant or the conflict is merely hypothetical, there is no constitutional violation. He's got to prove that there was an actual constitution. He cannot continuously just say, you, and you have violated my rights, and then slide those off and go, okay, now you, and you have also violated my civil rights. You got to prove it.
Right.
You got to have proof. When the theory of causation is a matter of pure speculation and is nothing more than a hypothetical argument, the pleadings are insufficient to sustain a compensable 1983 claim, which is what Mike has been saying the whole time. Accordingly, plaintiff's sixth cause of action fails to state a claim upon which relief can be granted, and as a result, dismissal is warranted. Judge Mike, do you agree?
Oh yeah, I mean this one's easy. This one gets dismissed. So a judge, I think they could dismiss the whole thing here, but it's certainly within the judge's discretion if they really want to give chilli leeway on a motion to dismiss. But you bang out this count, no two ways about it. I honestly have not read. I read the outline because I wanted to see the order stuff was put in, but I didn't read anything. And the fact that he got arrested on March 31st, and his interaction with the lady was on April 1st. It dumbfounds me. Yeah. It absolutely dumbfounds me. If an attorney did this, not him, but if an attorney did this, if I filed this, if Mike Gravlin filed this pleading and signed it, I would be hit with sanctions under Rule 11.
They'd be sanctioning your ass, Mike.
For placing my signature on this flaming turd that says that I got arrested because of statements that occurred 48 hours after I was arrested. It just makes me laugh every time I think about it. And he did it with confidence too. I'm sure he was super alpha when he filed. He probably cracked the desk. He probably used the stamp of 4 to do it. Only he, Thor, and Odin himself can pick the stamp up.
He who can have the power to wield the stamp.
For 2 again.
Rule the world.
Everybody resubbed to Law Talk with Mike right now. Plaintiff's seventh cause of action fails to state a claim upon which relief can be granted. There are 3 main requirements for a local government to be liable under Section 1983. 1, its employees' conduct must be pursuant to the local government's law, custom, or policy, which means that to hold the government, to hold the city has to have a citywide violation of civil rights. You can't sue the city for a violation of civil rights because, an off-duty police officer hit your car and then punched you in the face because you were bitching about it. That's not how that works.
Oh, can we punch Chilli in the face?
This arises from his allegations that there's a failure to train the officers, which is pretty common when you're dealing with a civil rights case involving law enforcement. Yeah, that gets thrown there all the time. But you have to actually establish that the training was either wrong or never took place what was supposed to. And he never does that.
Right. Where it's an institutional violation of constitutional liberties or constitutional rights. All right, number 2, its employees' conduct must be either unconstitutional or in violation of a right secured by a federal statute. And 3, that law, custom, or policy must be unconstitutional or otherwise violate a right secured by federal statute.
Okay.
Thus, a municipality cannot be held responsible for a constitutional deprivation unless... where's my mouse at? Okay, there. Unless there's a direct causal link between a municipal policy or custom and the alleged constitutional deprivation. In order to sufficiently allege a 1983 claim, a plaintiff must identify a custom or policy and specify what exactly that custom or policy was. Complaint fails.
There's your problem in a nutshell. That's where it should definitely be dismissed. He doesn't even allege that. He doesn't say they're doing this because the city of Ironton said, hey, go out and violate everybody's civil rights. Yeah. Which is, I mean, I'm being over the top, but they don't have some policy that would imply that.
Correct, Mike.
And he doesn't even allege it.
He just says because an employee did this, it is a violation or the municipality is responsible for that violation.
And no,
which is not true. That's what this is saying. It has to show that it's a custom.
Well, the term you're looking for is it's got to be basically a policy of the city. It's got to be like if you look in the city handbook, it says, hey, when someone comes to do this, you do this. Not that it was something that the person decided to do on their own, even if that action was indeed against the rights. Okay, now back to Father Skeptic.
Corporate, because it is a corporation. It's corporate-wide policy for everybody that's under the corporation of the municipality. Everybody must follow this rule, and this rule in itself is a violation of civil rights. That is where this would fall in. Go ahead.
He did a video where he was filing the suit, and it was hilarious. And I did a stream on that, and all I could see was the front caption, maybe the first page of it, and I could see he didn't name the Ironton Police Department. And I'm like, they're a necessary party. You have to name them, and then allege this violation, that some policy that led to this.
And I knew he didn't know what he's talking about.
I said it right in my video. I said your complaint's insufficient on its face. I don't know what to say.
All right,
I didn't bother telling him until now because I knew a motion to dismiss would come in. I wasn't going to help him.
Yes. Okay. So in the very next thing, it says a complaint fails to sufficiently plead a Monell policy claim where it fails to identify any specific customer policy, which is what you're saying. He's not identifying exactly what's going on, what the problem is, but instead alleges that the policies were insufficient in a generic way. Internal quotations omitted. Thus, a plaintiff must set forth more than a threadbare recital of the elements of a cause of action supported by mere conclusory statements. As the court fittingly explained in Kearney, this court understands Twombly and Iqbal are requiring plaintiff to allege some facts in his complaint to support his conclusory allegations that Highland Park fails to adequately train or supervise its police officers, which is what I think you were saying, Blue Bacon, right? Was the failure to train. Okay. And therefore their failure to train is what leads to systemic violations of rights, which is what his case is built on. Alright, so we'll just scoot on down. Let's see. To merely state that a municipality has a policy or custom is not enough. A plaintiff must allege facts demonstrating the municipality's policy, such as examples of past situations where law enforcement officials have violated constitutional rights. In this case, the complaint sets forth conclusory allegations that Lawrence County, through its supervisors, officers, employees, and trainings, promulgated the making of the unconstitutional acts as outlined in the foregoing causes of action. The complaint further claims that Lawrence County knew or should have known that their training and supervision of their policy makers, employees, and other officers must include clear knowledge of the constitutional nuances relating to their public service, and failed to properly train and supervise their employees to refrain from making unconstitutional actions in violations of the rights of citizens. Basically blaming the city for what he believes to be systemic civil rights violations.
In other words, he's an idiot.
The allegations set forth in the complaint are merely labels and conclusions and a formulaic recitation of the elements, which are insufficient to overcome a motion to dismiss. Thus, plaintiff has not identified any specific municipal policy, custom training program, or supervision policy to support his claims against the municipal defendants. Dismissing all claims against... Oh, wait. Yeah. They should be dismissing all the claims. That's what that statement was supposed to... Yeah, my tonal inflections were a bit off there.
Yeah, they were, Father.
I shouldn't have been preparing myself for a comma, but more for a period. But anyway, in this case, plaintiff's claim against Lawrence County fails to meet the Monell articulation requirement. The complaint fails to identify any specific policy or custom that was the moving force behind the alleged constitutional violation, and as a result fails to state a claim upon which relief can be granted against the aforesaid defendant. Judge Mike, do you agree or disagree?
Yeah.
3 for 3, Mike.
That's the reform. They just didn't do that. I forget that's the Monell standard that you got to deal with. I forgot because it's been a little while since I filed one of those. But yeah, they're toast right there. I think this gets granted. However, probably gets granted without prejudice with leave to amend. Not that he'll figure it out, but
yeah, I was about to say he has no idea what that means. By the way. Yeah, he could be sitting there with a pen and paper and notepad, and he's got to play that in slow motion to catch every word you just said, and then go and look up what each word means to understand that what you just said was that he could refile it later, amended refiling it later.
It's funny. I know how you could do it, but I'm not going to explain it to him right now.
Please don't, Mike.
Hey,
do you know California bombing? He's going to get a bunch of new words from those pages and then use them later and hope they work.
Well, I love how he says. I love how he's constantly said he's had 20 years of constitutional study, and every time he debates somebody, he says, "I learned something new. I learned something new." And we're all people that have been like looking into this for the past year. You know, he's done 20 years. Yeah, my ass. All right.
Because he only started a couple years ago.
We're approaching the end, guys. All right, defendants are entitled to qualified immunity. I'll let you guys kind of take over this. I'll read it, but I want to let y'all talk because y'all are more, lawyer and Leo. So, right, is that sufficient? Can I call you Leo, Leo, or is that a good way to?
Well, yeah, technically, yeah.
So I just want to make.
And for those who don't know, Leo is an acronym for Law Enforcement Officer.
I still hold the title. I don't engage in the actions so much anymore.
Okay.
Due to the nature of my job.
Close enough, Blue Bacon.
Yeah, we'll give you a pass, Bacon.
Blue Bacon just said he was a pig without saying that he's a pig. All right. D. Defendants are entitled to qualified immunity. Section 1983 claims are limited by the qualified immunity exception, such that a government employee will be shielded from liability so long as the employee acted under objectively reasonable belief that his or her actions were lawful. In a nutshell, that means that if a police officer makes a mistake and he does violate your rights, but the mistake he made was objectionably reasonable, meaning, let's say he gets a phone call, and in the phone call they say, there is a male running down the street, red hat, red shirt, red pants, red shoes. He's just confirmed shot 10 people, killed, and he's running north on this street. And a cop turns down that street, and they see a male, red, running in that direction, and they stop him, but it's the wrong guy. They didn't violate his rights. Because there's an objectively reasonable reason. I'm sorry?
It's a perfect hypothetical.
Yes, and it's
sustained.
Like, and it turns out there's another guy with all red, who's actually the proper perpetrator of the crime. But you grab this one. It's incredibly reasonable as a law enforcement officer that you do that.
And it's unlucky. It's unlucky, and it happens.
Right.
But
you're not out to deprive someone of their rights. You're out to do your job, and it's a reasonable thing.
Right, and this is why it exists, because there are officers out there that do go out looking to deprive people of their rights, and they lose their qualified immunity because of this clause right here. So this is why it's pertinent and important.
And they should. If somebody's got it out for somebody, and you have some evidence of that, and you really can find that sort of thing from time to time, great, and they should lose their qualified immunity, but it's all these things are very difficult.
Yeah. All right. A successful 1983 claimant must establish that a defendant acted knowingly or intentionally in violating his or her constitutional rights. Acting negligently or recklessly does not overcome the qualified immunity afforded to the government employee. The protection of qualified immunity applies regardless of whether the government official's error is a mistake of law, a mistake of fact, or a mistake based on mixed questions of law and fact, which is kind of what the scenario I just put out.
So you got to show the police officers really out on line, not in good faith,
Yes.
maybe slightly wrong, but trying.
Correct.
Yeah, you got to make sure that they're really.
If people aren't getting this by now, a 1983 claim is an incredibly high burden.
Because it's a deprivation of human rights. It's up there with, it's not as bad as a war crime, but it's taken seriously. Deprivation of human rights is taken seriously on the international level, and we take it seriously here in America as well. All right, to determine whether a governmental employee is entitled to qualified immunity, a court must consider whether considering the allegations in a light most favorable to the party asserting the injury, a constitutional right would have been violated on the facts alleged. Mike said this earlier. It's always in favor of the asserting party. That's why they have to be the ones that make the facts, because they need to be given every opportunity to show that their human rights were taken away. And then everything else is on the defending party to respond to that. It's a little bit backwards than it is with the innocent until proven guilty on the criminal level, I would say. A right is clearly established. Go ahead. Or is somebody about to say something?
Oh, no, sorry. So you're saying it's backwards from the innocent until proven guilty. Not entirely, because in this case, one could consider the police the victims, because the charges are against them, and so their innocence is presumed. And if facts aren't presented, then their innocence is presumed to be maintained. So the backwardsness is the placement of the government, not necessarily the presumption of innocence.
Right. Okay. Yeah. I got that right.
The real issue is that a motion to dismiss. And I may even be misquoting it, but motions to dismiss, motions for summary judgment, federal, state, there's usually some variation of you assume the facts most favorable to the non-moving party. So that's what it is. So because you're saying you want the court to dismiss them before they even get a chance to present evidence, you've got to show that they haven't even presented a case. So we're going to take any facts that they do allege, for instance, and say they could be true. Is there any construction where it might be right? And that's why it's very difficult on the motion to dismiss level, not on the case generally, but at this particular motion level.
All right. A right is clearly established if A.
And that's because basically that you're not even giving them a chance to argue their arguments is the reason, I believe there. Go ahead, Skeptic.
If a reasonable official would understand that what he is doing violates that right, which is that again would be he knows he's violating a right that would take away his qualified immunity. It would not be objectively reasonable at that point. He would be knowingly committing something that was objectively non-reasonable. Unreasonable. Qualified immunity ordinarily applies unless the contours of the asserted right were sufficiently clear that every reasonable official would have understood that what he was doing violated that right. In determining whether qualified immunity applies, these questions need not be considered in order. Moreover, the burden lies on the plaintiff to refute a defense of qualified immunity once properly pleaded. All right, Mike, you want to chime in on that? Yeah, are you in agreement?
Yeah.
Oh, okay, I'm sorry. As explained above, defendants... Go ahead.
They've got serious issues. Here's how you make a 1983 claim stick. I mean, if you want to see how it works and you can win this, you have something where there's police brutality and it's videotaped. Somebody just goes after somebody who's not resisting and they're jacked up and you have the video. Then you can show all of these things. That police officer isn't confused. He knows he's crossing a line. You know, think in like real world examples, like what would qualify. That's the sort of stuff you need. You need goods to make a 1983 claim stick.
Yeah. And in his goods, they didn't even handcuff him. If you remember in his arrest video, he got all the way to the back room and they didn't handcuff him not one time. I'm sorry, go ahead.
He's saying I don't like the arrest, but we have a videotape of them saying you got to leave, the place is closed, and he doesn't do it. Then he gets arrested. Then they don't beat him, they don't do anything. They take his phone, and that probably has evidence on it. That seems reasonable. It doesn't seem like a violation, like the police officer. Oh, I just want to violate your rights. It's like no, that's like procedure that makes sense.
Yeah. All right.
The arrest makes sense. All those things make sense, so it's just very difficult where he's coming from.
Yeah. All right, so here's the conclusion, where we finally reached the end, fellas, ladies.
Thank God.
For the reasons set forth above, the second and fifth causes of action against defendant Chapman, the sixth cause of action against defendant Jane Doe, and the seventh cause of action against Lawrence County fail to state a claim upon which relief can be granted pursuant to Civil Procedure 12b-6. Accordingly, defendants respectfully request this court to grant the motion to dismiss. And that's been filed. Certificate of service. It's all there. And it's on the Federal Pacer website, so anybody can check it out. We'll get over here.
That looks exactly like what I would expect.
All right, so we have one more. We have another video. So first off, I want to get your thoughts. We'll start with you, Blue Bacon. What's your thoughts on this thing?
It's about what I would expect as well. Chili's lawsuit was pretty much absolute garbage, and they're acknowledging that it's absolute garbage. If it does continue in any way, they're not going to have a hard time winning that case. Mm-hmm. Be like, look, we arrested it. We can prove he committed a crime, or we can prove that it is reasonable to believe he committed a crime. Qualified immunity probably doesn't even need to come into play because nothing we did was outside of what is appropriate or allowed by Ohio state law or any other law that would be applicable. And therefore, his lawsuit is just that, oh gosh, I'm mad that I got arrested, despite the fact and proof. He knew that what he was doing was a crime. He stated that he wanted to get arrested. He acknowledged that he had been told that he had to leave. He acknowledged that the time was 5 and that he knew that the place closed at 5 and that he was told if he didn't leave, he would get arrested. Now, the only thing I can see him trying to get a foothold with is him saying, I said I would leave if they were going to arrest me. Because he stated that multiple times. When in fact, the reality is he stated, I will go with you if you're going to arrest me.
Yeah, he did. And she goes, okay, come on. And she goes just like that.
She tried to spin that. And I think he would continue to attempt to spin that, and it would be very easy to be like, hey, Jamie, pull up that video. And then boom. Yep.
All right, Mike.
So he's got nothing.
Mike?
Yeah, his video doesn't help him.
No. Not at all.
His video shows a good arrest.
Let me, yeah, it does. And I believe his lawsuit's frivolous. I don't think it'll stand a chance.
No.
Let me pull up our next video. This is a court fail, okay? So this one's good.
And to hear that, you would have to have been here this afternoon as we had that particular call on the A episode. If you haven't, just take a look. We do have it, of course. It'll be listed as May 16, Part A. But with that, Part B will come to a close. Come back later tonight in the overnight for Art Bell, the final part of Lucid Dreaming. So until then, please make sure you do like, share, and subscribe. Get us to the goal of 50,000 views, 1,000 subscribers. So Boxy over at Extra sends us those nice red boxes we can send to all of you. And of course, that Google puts us on the algorithms. So until next time, like, share, and subscribe. Again, be kind to one another and release the Krakens as we march along here from day one. Have a great evening. We'll see you in the overnight.